As you may know, the America Invents Act was signed into law on September 16th of 2011, and it creates several new procedures for challenging patents at the Patent Office. But did you know that starting on September 16th of 2012, inter-partes reexaminations will no longer be available as a method for challenging patents at the Patent Office? And therefore, you should consider using inter-partes reexam now, while you still can, before you lose out on this opportunity. Although the new proceedings will be attractive in many instances and have many attractive features, they're not available and not appropriate in all circumstances. For instance, the new post-grant review proceedings will be, with limited exceptions, available only for patents that have a filing date after March 16th of 2013. And therefore, post-grant review will not be widely available for many years to come. Likewise, the new inter-partes review proceedings are not available for all potential challengers, nor are the timing provisions appropriate in all circumstances. For instance, if you're a defendant in a patent litigation, the clock is already ticking for you to bring a challenge at the Patent Office in an inter-partes proceeding. And this is because if you've been served with a patent infringement complaint more than a year ago, then you will be precluded from requesting inter-partes reexam because there's a 1-year time limit for doing so. Excuse me, for requesting inter-partes review, there's a 1-year time limit from service of the complaint. And therefore, if you've been served with a patent infringement complaint prior to September 16th of last year, you will be completely prohibited from requesting inter-partes review based on that patent. And likewise, if you've been served any time since then, the clock is ticking. And even if inter-partes review is available to you, the timing provisions associated with inter-partes review may impair your ability to use inter-partes review as leverage in licensing or settlement negotiations. And this is because there's a 9-month window associated with filing a petition for inter-partes review. You cannot file that petition until after 9 months after the patent is issued or until after 9 months after reissuance of a patent. And therefore, if you're a defendant, say in a fast jurisdiction or a respondent in front of the International Trade Commission, this 9-month window may impair your ability to use inter-partes review as leverage in your settlement discussions, or likewise as leverage in your licensing discussions. In thinking about the 9-month window, let's say there's a patent that issues on July 3rd of this year. You would not be able to request inter-partes review of that patent until after April 3rd of 2013. But you could request inter-partes reexamination of that patent, assuming it has an appropriate filing date, through September 15th of this year. And therefore, you should consider using inter-partes reexamination while that proceeding is available to you, because otherwise you may lose out. And there's at least one substantive difference between inter-partes reexamination and the new proceedings that will be available under the America Invents Act. And that is, challenges based on obviousness type double patenting are available in reexamination, whereas a challenger will not be able to rely upon that legal doctrine in inter-partes review proceedings or in post-grant review proceedings. So that's another reason to consider inter-partes reexamination now while it still exists. Of course, there are also procedural differences and cost differences associated with these proceedings. And the best option for any challenger is going to be dependent upon the particular facts of the situation. But certainly, while inter-partes reexamination still exists, you should consider using it before you lose it. Thank you.